Okay, let's move. Today's, today's discussion. Okay. No one is watching this video. Oh my God. Okay. Just the hearing system. Okay. Only one is watching this video. No problem. Today's session on point of the homicide. Under the okay. Only one is watching this video. So the truth through this process, our discussed media in terms of homicide. We will discuss in terms of culpable homicide and murder under the Penal Code 1860. First of all, we would like to discuss in terms of culpable homicide. So, this concept is not clear to us. Today's session will actually make it clear towards the students of law. First of all, we have to discuss in terms of homicide. So, what is homicide? Under the Penal Code, we must have knowledge in terms of homicide. Just share this video and how can, oh my God. Okay. Just follow the instruction of mine from the side of law doctor to you. At first, we have to understand regarding the homicide. What is the meaning of homicide? The killing of man by another man. This is called the homicide. So homicide is of two types at first. Lawful homicide and another is unlawful homicide. So lawful homicide is of two types. Excusable homicide and justifiable. This is the justified homicide. Now the question may arise before us, how can actually we discuss in terms of homicide? That the culpable homicide and non-culpable homicide. So that should be focused. But later we will discuss in terms of Penal Code 1860. The homicide, lawful homicide and unlawful homicide. So what are the lawful homicide? Those are excusable homicide and justified or justifiable homicide. An unlawful homicide prescribes that the culpable homicide not amounting to murder. And section 304 of the Penal Code. And the suicide, section 305 and 306. And not only that, the murder, section 300. And homicide by rash and negligent. And then the act and the culpable. This is the 304A. This is the discussed murder. This is the landmark decision, Tariq Masood and Catherine Masood case. So how can we discuss in terms of the culpable homicide and on the other hand, non-culpable homicide? First of all, we have to focus on point of the non-culpable homicide. What are the actually the provision of laws in this respect? Those are non-culpable homicide. Non-culpable homicide prescribed that the section 76 to 79. So why this is treated as the non-culpable. This is the justifiable homicide. So there is a two types of non-culpable homicide. You have all know in this regard. This is the justifiable and excusable homicide. So what exactly the justifiable homicide? Section 76 to 79 prescribes in this regard. Section 76 prescribes that we have all know in this regard, this the act done by force or mouth or by mistake of fact, believing himself bound by law. This is stated as the justifiable homicide or the justified homicide. And not only that, the section 77, act of judge when acting judicially. This is treated also the justifiable homicide. So section 76 to 79 and 81 and the 100, 03 prescribe in this regard that the justified homicide. And justified, excusable homicide prescribe that the 80. So what exactly the 80? Accident in doing a lawful act. This is treated as to the excusable homicide. And not only that, 82 to 85 prescribe that the excusable homicide. And 87 and 88 and 92 prescribes in this regard that the excusable homicide. And now I would like to discuss in terms of culpable homicide. Culpable homicide prescribes that is section 300. This is the murder, So not only that the section, but exactly the section 301 prescribe this. And not only that 304 A and then 305, 306 and 307 and 309 will discuss in terms of that the very case, the culpable homicide. So we have all know in this regard culpable homicide amounting to murder and culpable homicide not amounting to murder. So that should be focused here. So now I would like to discuss in terms of side by side. This is the landmark decision to make it clear to you. This is the Sharmin murder case. So the landmark decision prescribes, if we actually focus in terms of the landmark decision or the leading case, that can be much more lucid to you. How can we actually justify and how can we actually differentiate culpable homicide or non-culpable homicide? First of all, we have to focus in terms of Sharmin murder case. The Sharmin murder case is one of the most notorious criminal cases in the history of Bangladesh. Munir Hossain, a wealthy industrialist, killed his wife Sharbin Rima on April 9, 1989 as the culmination of a long-running affair with his mistress Hosniara Kuku, a middle-aged woman and the wife of a disabled man. Both Munir and Sharmin came from, what exactly the came from system? Came from the prominent families. Munir was the son of Dr. Mehrun Nisa, a renowned physician, where Sharmin was the daughter of an intellectual who had been murdered in the Bangladesh Liberation War. The murder investigation and the subsequent trial received blanket coverage in the press. Every new revelation was created with a dramatic headlines. This is the dramatic headlines in the newspaper. We have all know in this regard. Not only that, we have knowledge in terms of the Commonwealth versus Lakava in 2003. This is the landmark decision from the side of ESA. So this is the landmark decision. The defendant in this case, Thomas N. Lakavala, was convicted of the deliberate premeditated murder of his wife. This is the wife killing case. You have all know in this regard. Well, viewers, so Lakava admitted to the shooting and the killing, but the claimed that due to his diminished mental capacity. So what exactly the mental capacity? We have no power. This is a psychiatric treatment from the side of doctor. This is in terms of the California definition employed malice to describe an unintentional killing that is charged as murder because the defender intended to serious bodily injury and acted with extreme recklessness. So this is the recklessness is very much the degree of which is apex. So that's why this is the charged murder case in terms of the murder. This is culpable homicide. This is not amounting to murder and the amounting to murder. This is the issue or the issue of priming issue press club in this regard. That what exactly the issue in this very case, Commonwealth versus Lakava in 2003 case. The fact press club that the defendant Thomas and Lakava was convicted of the deliberate premeditated murder of his wife. Lakava admitted to the shooting and the killing, but he claimed that due to his diminished mental capacity, he could not, from the requisite malice, when he committed the killing so as to be convicted of first-degree murder. The Supreme Judicial Court of Massachusetts found that the Massachusetts law permits psychiatric evidence to attack the premeditated aspect of murder. However, the judge's instruction to the jury regarding the definition of murder was sufficient to render the error harmless according to the code. Many states use the California definition to imply malice to describe the unintentional killing that is charged as murder because the defendant intended to do serious bodily injury and acted with extreme recklessness. For example, if an aggressor punches a victim in this nose, for example, in such way. In such way, this is the punching to nose. Oh my God. So, for example, if an aggressor punches a victim in his nose, intending only to injure the victim's face, for example, it shows. So this is the aggressor made it starts with murder. This is not totally imagined in such way. This is the murdering system. This is not murder. This is not culpable homicide. But unfortunately, for example, if an aggressor punches a victim in the nose in such way, intending wanted to inquire what exactly injured the victim's face, the aggressor may be charged with murder if victim dies from the blow. The infliction of serious bodily injury becomes the equivalent of an intent to kill when the victim dies. My God. The aggressor in such case didn't have the express desire to kill the victim, just escaping or clapping something and punch to nose. This is not the intention of the murder to kill the person. And that's why this is not murder. In People versus Dellinger case in 1989, this is the Langman decision in the war. So, defendant Lieutenant Dellinger was found guilty of murder of his 2-year-old stepdaughter. The primary cause of the child's death was a fractured skull caused by trauma to the head. So what is the scaling and the injury is found her head. However, the evidence shows that the child had large quantities of cocaine in her system when she died. Moreover, her mother discovered that the defendant had fed the child where to the baby bottle due to the defendant's violence disregard for the life. The verdict of murder was firm according to the California Supreme Court. So this is another Langman decision in terms of that. The newly born baby was had to lead the killings of the accused falls within the purview of exception 1 of the section 300. Oh my God. Whether this the Tarver versus State case prescribed this is the defendant Jimmy Ray was convicted of murder of his life. The couple had contemplated divorce, but had apparently reconciled. After their reconciliation, they went together to the defendant's parents' house to the red and the broad shotgun as they walked to the parents' house. This is the landmark decision, Turner versus States, the famous case, 2001. So this is the landmark decision. How can we actually discuss to understand the murder under section 300 of the penal code? This is the penal code. This is the landmark decision, the Turner versus State, 2001. The defendant Jimmy Ray Turner was convicted of murder of his wife. This is the wife killing case. But unfortunately, this is the what is a mistake or the erroneous decision from the code. This is the shooting gun. This is the loaded. This is the trigger. But unfortunately, this is not known to the accused. This is the accident to murder his wife. So, and that's why this is not the culpable homicide. This is the culpable homicide not amounting to murder. So this is under section 299. This is the section which is deals in this regard. This is the Turner versus Strait 2001. So this is the erroneously killed or the killing his wife. Oh my God. And not only that, so the section, but exactly the state versus Abdul Hawladar. So this is the landmark decision in 48 DLR 1969 SCD 2000. Oh my God, 257. This is the phase number. Well, this is the Bangladeshi case law. And how can we actually distinguish between the two? Culpable homicide amounting to murder and culpable homicide not amounting to murder. That should be focused here in the state versus Abdul Hawladar. This is the landmark decision where all that the accused intended was the strike his where and the strike by mistake hit. Oh my God, we have no knowledge at all to distinguish between the two. So the case phrase candidates in this regard, so this is the landmark decision you all know in this regard. How can this is the common lakaba and this is the landmark decision, the state versus Abdul Hawladar. When all the accused intended was the strike is where the strike by mistake hit their newly born baby. Okay? Newly born baby. But the mistakenly this is the hit and which led to the killing. This the baby was killed just erroneously, the mistakenly hit his wife at the time newly born baby was killed by this hitting of husband. Oh my God, this is the sad media. So the such of the accused falls with the problem of exception. This is what exactly the provocation, the sudden provocation actually prescribed in this the exception of this 300. This is action. This is the exceptional cases in terms of the culpable homicide. This is not murder at all. And not only that, so the Sudhir Kumar Das versus the state, this is the landmark decision, and 60 DLR 2008 and page number 261. This is the landmark decision in our country. The murder having taken place while the accused was living with his wife house. The accused husband under section 106 of the Evidence Act is under obligation is explained how his wife and met with her death. This is the web killing case, another case. In the absence of any explanation coming from his wife, none other than the accused husband was responsible for causing such death. There is no intention to kill his wife. This is the erroneous, what exactly this the mistakenly, what exactly the thematic approach in terms of this culpable homicide. This is not amounting to murder. And not only that, so this is the Kashiruddin versus state case, that the 24 DLR 164 on the page number and the section 304. This is the husband cannot be let responsible for the murder of his marriage before they used to quarrel occasionally. There is no quarreling, quarrel proceeding. This is the sometimes the husband and wife quarrel is other. At the chance of the provocation, this is at the time how can actually that hit his wife and killed his wife. This is the mistakenly and the erroneously killed his wife. This is culpable homicide. This is not murder at all. And sometimes husband and wife, which we of all know in this regard, what exactly the thematic is calling murder, and then what exactly is one of causing just death, and this is occasionally quarreled is other. At that time, this is not treated as murder. This is treated as culpable homicide. And under section, what exactly the systematic way to Naushad Ali versus Stats, 39 DLR Appellate Division 194. This is the prisoner punishment for murder is death or transportation from life, which is at the discretion of the court in consideration of the fact and circumstance of the case. And Mughal versus State of AP, Andhra Pradesh, this is the All Indian Reporter 2011, Supreme Court 184, this is the page number. In this case, the appeal and murder and cast air from the deceased incident taking place in the house of deceased, evidence by word and the employee truthfully describing events without word exaggeration and cannot be discarded on the ground of interest witness. A faulty investigation. Where are you falling to collect blood-stained earth from the place of incident? After three on this is the accused snatched his bag and run away. After dismissed and judgment upheld by the Supreme Court. And not only that, the versus Singh versus State of Punjab, All Indian Report in 1950 and Supreme Court 465 that the faith observed that to bring the case under this part of this section, the prosecution must establish objectively. So those are the criteria through which we have to prove this is that a bodily injury is present. That should be observation that a bodily injury is present. Whether this bodily injury is present or not, that should be focused. And not only that, that the nature of injury that must be proved. And it must be proved that there was an intention to inflict that particular bodily injury. That the injury inflicted is sufficient to cause that in the ordinary course of nature. This is purely objective. In this regard came what is said Nanavati versus State of Maharashtra, All Indian Report of 1962, Supreme Court 605. This is the phase number. What is the fact of that case? This is the fact of this case. Was accused a naval officer. Well, this is the fact of this case. The accused, a naval officer, was charged with the murder of Prem Ajua, a businessman of Bombay, for having illicit intimacy with his wife. Oh my God, Sylvia. So the illicit intimation of his wife, Sylvia, and coming to know from his wife about the illicit relationship with the deceased. He went to the ship and took from the stores a semi-automatic revolver and 6 cartridges when a false pretext loaded the same, went to the flat of Ajua to his bedroom and shot him dead after a heated exchange of where, oh my God, what a heinous crime. This is the illicit intercourse. That the issue raised in terms involved. What is the issue involved in that very case? In this present context, the only question relevant to our purpose is whether the appellant was deprived of power of self-control by sudden and grave provocation, discovering the offense under exception where to the section 3000. This is the systematic way what exists under IPCC. Oh my God. So this illicit, but it's illicit relation with his wife. So decision, what exactly the decision in this case? It was contended on behalf of the appellant that the act of Ajwa, namely the seduction, what except the seduction of Sylvia gave provocation, though to the fact of seduction was communicated to the accused by Sylvia. For the ascertainment of the suddenness of the provocation, it is not the mind of the person who provokes that media, but that of the person provoked is decisive. On behalf of the state, it was argued that though a confession of the adultery by wife may in certain circumstances be provocation by the paramour himself under different circumstances, it has to be considered from the standpoint of the person who conveys it rather than from the standpoint of the person who gave it. It was further contended that even if the provocation was deemed to have been given by the Ajwa, and though the said provocation might have been kept, it cannot be certain. And for the provocation given by Ahuja, but exactly Ahuja was in the first. And it was observed that the test of grave and sudden provocation is whether a reasonable man belonging to the same class of society as the accused placed in the situation in which the accused was placed would be so provoked as to the loss his self-control. That should be focused. In India, words and gestures may also, under certain circumstances, cause grave and sudden provocation to an accused as to bring his act within the first exception to this section 303 under the what exact the IPCC, what exact the penal code 3030. Whether this is exceptional cases or not, that can be held in that very case. Not only that, Jasa Singh versus State of Haryana, there's a trust made under section the exception 2020 the effect of this case that what a dispute land arose between the disease, and this is not counted as the issue may arise the exception case and Duki Singh versus state case prescribe the fact of this case is one kill of his brother's disease and come to the brother residents how they smoking hookah and setting them. So how this is the exception 3 prescribed in this respect. And not only that, so this is the case law in terms of this is the Basan Singh versus the Punjab, the Supreme Court, the matter report, and the held in the province of death penalty and alternative punishment for murder and section 302. This is under the systematic way. And not only this is the syllabus by state of Andhra Pradesh, All Indian report, and then 2011 Supreme Court says 604. This is another landmark. And Ramkumar state of Rajasthan, this is 1970. This is the landmark decision. And not only the last but not least, the R versus Tabis and 1883. The cap load is today and the injury to inflicted rendered an operation unadvisable. And the foreman told the operation chloroform was administered today. So this is the probing media into the chloroform, and that's why this is the culpable homicide under the IPCC. This is the land minister Ramkumar versus State of Rajasthan. So in tracking the several decision from the side of the Indian Supreme Court, and not only this is the Supreme Court of our country, like this the Bangladesh Supreme Court, which will take several decisions from this we have to discuss, and we will prove in tackling this landmark decision or the leading case in our country what is actually the excusable. This is the culpable homicide, and not only that, this is the culpable homicide or the culpable homicide or the non-culpable homicide that should be, and the synopsis goes again please. So the culpable non-culpable homicide prescribed this is section 76 to 97 and the area, and this is the 100 and the 103. This is the what exactly the thematic approach in terms of this is the justifiable homicide or the justified homicide, and this is the non-culpable homicide. Where and not only that, so this is the excusable homicide. You know, this non-culpable homicide is of two types. This is the justified, and not only this is the excusable. What exactly the any section 80 prescribed that, and not only the 82 to 85. This is the 82, 83, 84, 85. So those are the section which deals with the excusable homicide, and not only the 87. This is the section which deals in this regard. Then the 88 and 92. Those are the section which deals in terms of excusable. With this is under the heading of the non-culpable homicide. Oh my God! And not only that, so this is the culpable homicide deals in this regard. How we will distinguish them to the 300, and this is not only that 301 and 305 and 306 and 307 and 308 and not only that 309 prescribed in this regard. This is the culpable homicide, and we all know this is culpable homicide prescribed in the 2000. What exactly the 299 and then murder 300. And not only that, this is the section culpable homicide by causing death of person other than person whose death was intended 301, and this is the punishment for murder. This is 302, and not only this is the what exactly the punishment for murder by life convict 303, and not only the punishment for culpable homicide not amounting to murder 304. Of course, this is 304. This is the culpable homicide not amounting to murder and causing death by negligence 304. And not only that, this is the causing death by the rash driving or riding on the public way 304, and B, an abatement of suicide of child and infant person 305, and not only that abatement of suicide 306, and the attempt to murder 307, and attempt to commit culpable homicide 308, and attempt to commit suicide. You know, this is 309, and tag and punishment 30, 311. Those are the section in terms of the culpable homicide amounting to murder and culpable homicide not amounting to murder. But what is the distinction between the two that can be focused earlier in Reg versus Cabin? This is the landmark decision we of all know in this regard. What actually we of all distinguish between the two? First of all, we have to discuss in terms of the definition. As to the definition, we have to differentiate between the two, and then what exactly the provision of laws, and then what exactly the elements. And not only this is the what condition applies to be a culpable homicide and not a culpable homicide. That should be focused here. And not only that, the example and on proportion as to the punishment and as to the landmark decision which will be discarded shall be murder case, Ramkumar versus State of Rajasthan, those are the landmark decisions in the world. We must have knowledge to prove that. Until or unless we're nothing in our society to control the society, and we have no power to enlighten the society, and we have no power at all to represent our country like Bangladesh towards the whole world. And we know, according to Marshall McLuhan, this is the global village. We must have knowledge to represent our country towards the whole world, towards the America, towards Canada, towards the UK, United Kingdom, and United States of America, with Australia. We must have knowledge at all. This is the murder. So what exactly the culpable homicide and murder? The definition in every country is varied among other. The definition of murder is different in nature. For example, Bangladesh defines in such way, in another way, in 303, 300, and not only the, but exactly the thematic approach. This is the definition of murder is varied in every state, like China and India, or Canada, and not only that Australia, Russia, and not only that United States of America and UK, United Kingdom, and every state that the definition of murder is different in nature. So today's number, we must have knowledge, and today's number, and we have to discuss later in terms of several, but exactly the probation of law. Today's number. Bye bye.